First thing is, Emily, that revocations used to only happen if there is any new information that used to occur. For example, if somebody has a DUI, recent DUI, and they have a stamping, and we know we used to get the visa revocation. If there is any new information that is found that either this guy has committed some fraud or involved in a criminal activity that they were not aware of. But now we started seeing new trends somewhere in the December first week onwards, where even if the people have had the records previously and they got the stamping, they were all good. Now they are getting their visa revoked. There is no public statement from USCIS. There is nothing anywhere, but their visa is getting revoked. Now, it's very confusing to me. Now, in the early part of 2025, we got F1 visas revoked, and at the same time, their services was suspended. And of course, we know Stephen Brown and other people have went to the court and got it reversed, where they were successful in getting reinstatement of the service system. But of course, they are not successful in getting the visa revocation taken back. However, this time we have seen that they have not issued any press statements, but they just issued a visa revocation. Let's say, for example, somebody has a DUI 12 years ago, and after that, they got visa got revoked. They went for stamping. They did the psychiatric evaluation. They got the medical evaluation. They got the visa. They disclosed everything, and after that, they got multiple times visa. But now their visa got revoked. Is there any public statement from the immigration or from the administration, DHS, anywhere?
No, definitely not. I mean, they have their random social media posts from the State Department reminding everybody that having a visa is a privilege and not a right, and we have the authority to revoke visas at any time, which they do. However, as you mentioned, these are people who've already disclosed the information. So it's not that there's new information that causes the Department of State to question whether you qualify. They've already determined these people qualify. In some cases, they even got visa stamping during the current Trump administration twice and still had the visa revoked. Um, so that tells me this has nothing to do with actual public safety. This is more just a way to show the anti-immigrant crowd that, hey, look what we can do. We're going and revoking 85,000 visas. It means nothing because the people that are in the United States, it's a prudential revocation, meaning that it doesn't take effect until they leave. And all they have to do is go for stamping, provide the information again, show the same documents again. There's nothing that's changed in the law. There's nothing that's changed in the documents. The crime hasn't changed. Yet we have to go through this extra hoop. So nothing's really changed. Nothing's been announced other than just this new administration is trying to be as anti-immigrant as possible.
So, Emily, what is your advice to people who previously we told people not to travel when the we are going for visa stamping? We said it 13 times at a stretch. Now, what if the guy already have a visa stamping? Would you suggest them to go, or what do you suggest them to do right now?
Yeah, I would definitely advise against it, particularly for anyone who's had any kind of past law enforcement interaction. So if you, even if you've, if there was an arrest, a citation of some sort, and it was dismissed, it's been expunged, no guilty finding, anything like that, still you should avoid travel because at any given moment, if you happen to be outside the country when they revoke that visa, now you're going to be stuck because you're going to have to wait to get a new visa interview appointment. That might take months to do. And then you're going to get a 221G as they review the documents and do all of this extreme vetting that they're doing. So it's a big risk to travel for anyone in that situation. So just because you have a valid visa stamp, the idea that they can take it away by revoking it at any time for any reason is enough of a risk to say you should not travel until this administration is out of office.
I just recommend everybody, even if you don't have a criminal record, just don't travel because they are changing the rules every month. We don't know what they're going to come. They're adding banning certain countries to ever enter into the country at all, and that list is growing too. So I definitely recommend not to travel, even if you have the visa stamping too. Um, Emily, with regards to the second topic, that we're expecting longer visa stamping timings, particularly in the consulates in India, though. We have seen that US consulates in India are backlogged significantly. And now, with the new social media vetting, we have seen that visas are already been postponed from December all the way to even October of 2026. Now, what do you expect for the people who are going forward when they are applying for the H-1B or H-4 stamping? Is that going to be like, is the times are going to get better or is the times are going to get worse?
Yeah, I don't expect anything to get better during the current administration. They are anti-immigrant. They do not want immigrants coming into this country. And an easy way to keep them from coming into this country is to not give them the visa. So anything they can do to make it more difficult by delaying appointment availability. And then once you do have an appointment, delaying the actual process because they're claiming they have all these different things they need to check, social media, and we're checking criminal records and all that sort of thing, which they were doing already, but now they're using as an excuse as to why they can take it their sweet time to process anything. So I would expect we're going to see additional administrative processing, more 221Gs. The process itself just taking longer as they claim they have to do all of these extra checks now.
We've already covered on the lottery system. From the new lottery onwards, that's going to start in March of 2026. It's not going to be the old system. It's going to be only waged based. That means that there are 4 levels of wages. Level 1, which is the entry level. Level 2 is mostly like you don't need any supervision. Level 3 is you're kind of managing some people, but then you have the level 4 where you're high level manager, where all these 4 levels are there. So people with level 1 wage will be only be given one chance. People with level 2 will be given two chance. People with level 3 will be given three chance. It's kind of not three, but you'll get like more chances to get the lottery system though. So that higher the level of wage is, the more chances you will get in the lottery. That is what the new system will be. That is how the new quota system will be. Unlike previously, where you were being randomly selected, that is not going to be there. The regulations are going to be published in a day. They're not published yet, is it right? They'll be published in a day or two.
Right. Yeah, December 29th, I believe, is the official publishing date, but the advanced public inspection regulation is available, so you can read it and look at it. It's about 300 pages. And they made very clear they are intending for this to be used in the upcoming lottery that will happen in March 2026.
And Emily, do you expect some challenges in the court on this one?
Yeah, it's definitely being discussed right now because I think the biggest issue is that the statute passed by Congress, which created the H-1B program, um, makes no requirements that visas be favored towards high wage individuals, high prevailing wages. If we wanted to promote high wage individuals, they would likely qualify for an O1 visa, which has a wage component to it as one of the factors. So that's not what the purpose of this visa was. It is meant for jobs that just normally require at least a bachelor's degree. In a specific field of study. So adding this wage requirement to it that favors some wages over others is definitely not in line with what Congress intended. So that's kind of one of the major challenges to it. And then also the statute makes it clear that the visas should be distributed basically in the order that they're filed. And this is, and their way of interpreting that up until this point was, well, if they're all filed at the exact same moment, then we just do a random lottery. And that's how they filled in that gap in the regulations in the statute. But now they're claiming that we have the authority to change the order in how they're filed based on prevailing wage levels. So I think that could be attacked as well. So we might see this, even though, and also I think, this isn't the first time the Trump administration has tried to make a wage component to the H-1B. Previously, they tried to issue a regulation that basically went by highest salary first. So whoever had the highest job offer money-wise the visas would go there first and going down the line. That was struck down in the court partly because it was issued as an interim final rule, meaning they skipped the notice and comment and tried to claim that there was some emergency situation that required them to forego that and go straight to issuing a final regulation. This time around, they did do notice and comment, but it's the fastest notice and comment I think I've ever seen in 20 years doing this. I mean, they started the regulatory process on September 24th, 2025, right after the presidential proclamation that added the $100,000 fee. And it is December 23rd, 2025, 90 days. That's all it took. And 30 of that time was them receiving comments. So they literally had 60 days where they reviewed 2,700 comments. Every single comment that opposed the rule, they basically said, we disagree, with very little analysis to it. So it's really questionable whether they actually considered the comments, especially because they didn't change anything in the final regulation. Normally, you announce your proposal, you take into consideration the comments that stakeholders provide, you make changes based on some recommendations, and then you issue a final regulation. It's slightly different than what was initially proposed. This one had 0 changes to it, which tells me that they just wanted to go through the motions of notice and comment just to get it out in time for this year's lottery.
Social media vetting is going to be permanent at this point of time, definitely until this administration is gone. It is going to be there unless some court comes and rules in our favor. We don't know after this administration is gone how many of these things will be carried forward for the next administration. It will depend upon the elections, who's going to win, if that guy is going to continue. But at this point of time, it looks like the social media vetting is going to be there. The main problem for a lot of the applicants is nothing that there is any information that will be derogatory for them, but more this is a kind of delay tactic. The administration, because they cannot deny the application based on certain things, they are trying to delay it, so that delaying is going to eventually fall out where the person will lose the intention to come back into the United States. This administration is trying to do every effort where a person should not enter here on a work visa.
All right, should we go to questions?
Sure. Go ahead.
All right. So yeah, Nikhil says, how likely are these changes for the new wage-based H-1B lottery to be challenged in court? I do think that there are definitely discussions among attorneys looking to challenge this because it's not in line with what the statute says and what Congress intended. So we should likely see that in the coming weeks, I would expect, in the hopes of getting some sort of injunction before the lottery happens in March.
A lot of people's the priority dates is becoming, for some people, the priority dates is becoming current in January of 2026. What are the action that they need to do to get the green card, though? Here is the thing, though. If your medicals were submitted more than before November of 2025, that means more than 2 years ago, that means that you need to have a new medical according to the regulations. So if you don't submit the new medicals, they cannot approve your green card. So you may want to submit the medicals. There are different ways of submitting the medicals. One way of submitting the medicals is you can submit along with the 485J supplement. 485J supplement is used when you file the 485 application, confirming that there is a job offer with the company. It's also used when you're changing from company A to company B. After the 180 days you are present in United States, in adjustment of status, you can move. That is porting of the employment. Now, some people ask, hey, I have already filed with the new company, or I'm still working with the same company. Can I still file the 485J supplement? Yes, you can. Now, if you want the medicals to be reached to the file, that is a better way. If the company is not willing to, you can self-file the medicals. That is the best thing. What I suggest to you is that once you file the medicals, wait for 1 week or 10 days. If you don't get an approval, I want you to consider suing the USCIS. When you sue the USCIS, all you're asking them is that, look, 485 was supposed to be filed, adjudicated within 180 days. And your application has been pending for more than 2 years, I guess. Based on that, you should request the USCIS just adjudicate the application, take care of that application. And if you are interested in, contact Stephen Brown. He's the litigation chief in our office, who's willing to take your case to approve your adjustment of status. Because if you don't, though, you know that the priority dates will move forward, move backward, forward and backward. So if you get this one resolved right now, then you don't have to worry about, most probably you don't have to come to this every Tuesday in the evening and listen to us, because once you get the green card, you may not need us. So definitely, I would like you guys to consider suing if the priority date is current and they don't act on your adjustment of status.
Sid Mohan says, what will be a good time to go for the first time H-1B stamping next year, given all the visa appointment uncertainties? The H-1B renewal is in September 2026. We don't recommend a good time for going for H-1B stamping. If anything, it would be after January 20th, 2029, when we have a new president, assuming the new president is not worse on immigration. So you should not go for stamping at all right now.
Tony118 from YouTube has this question. Received a notice of intent to deny for the past arrest for a dismissed family violence case. How to respond? Definitely, a domestic violence case is considered a very serious offense in immigration, though. You have to definitely hire an immigration lawyer. What we closely look into is, it's not the case is dismissed or not, whether or not you have admitted to have the wrongdoing. For example, if a lady has beaten the husband, um, and she told the police that she beat the husband and she felt guilty about it, she felt sorry about it, and the husband did not pursue the case, and the case is now dismissed. But she admitted to have committed the particular offense of beating the husband. Now, that is a very serious offense according to USCIS. So, even though the criminal courts may have excused for whatever reasons they may be, the immigration may still say that according to the police report, she admitted to the crime. They may still put her into proceedings. They may still deny the H-1B. So definitely, if there is a notice of intent to deny, that is a serious matter. We have seen RFEs to come for biometrics, but if it's a notice of intent to deny, you need to take it very seriously.
Sonali says, what is the probability of the Trump administration softening its stance on legal immigration in 2026? Well, I can't guarantee anything in immigration law. As an attorney, that would be unethical of me, but 0% chance that the Trump administration will soften its stance on legal immigration in 2026. There's just no way. This is just the beginning. So those of us that dealt with the previous Trump administration, it took about a year for things like this to start happening in high-skilled immigration. Once it started happening, every month there was some new horror that was unleashed by the Trump administration, and it continued his entire 4 years. That's the exact same thing that's going to happen here. Where we're at is just the beginning. We've still got 3 more years of this, and it's going to keep getting worse. We're going to start seeing new types of requests for evidence. With H-1B petitions, L-1 petitions. We're going to see new reasons for denial. We're going to see changes in prevailing wage methodology. They're proposing a regulation dealing with I-140 petitions that nobody knows what's in it. So this is not going to get better. It's only going to get worse from here.
Vinod Kumar has this question. How many hours of unpaid volunteering for nonprofit can a H-1B do? I want to be very careful on this, though. The nonprofit volunteering should be it should be real for non-voluntary. Let's say, for example, you own a restaurant, you are part of it, and then you are going there every day to volunteer for working in the restaurant. Is that considered to be volunteer? No, because you're expecting a profit from there. How about if you are working for, let's say we have in Houston called Telugu Culture Association, or if you are a member of a NATA organization, that's a Telugu organization, NATA or ATA or BATA or something like that, the Telugu organizations. So if you are spending a lot of time on it, I mean, what profit do you expect from these Telugu organizations? What profit do you expect when you go and serve in church or temple or mosque? None. You don't. I mean, we're not speaking about spiritual things, but we're only speaking monetary. So if you are doing that kind of voluntary job, I don't have a problem. If that voluntary job is 60 hours a week, I don't have a problem. But yeah, if your friend or relative have a restaurant and you are going there to do a voluntary job, I may have a problem because I don't think so there you're going for voluntary services. You're going there for some benefit. So definitely depending on the job though. If it is truly voluntarily, I don't have any problem you doing 60 hours a week.
Kunal says my priority date will be current in January. I already filed in April 2022. Should we complete the medicals now and keep them ready so that if USCIS issues an RFE, we can submit them immediately? Yeah, that's a great idea. When we saw that happen before in 2022 for October 2020 cases, we did recommend the same thing. You could even do 2 medical exams, get 2 sealed envelopes, send one in now before they ask for it as an interfile and ask them to place it in the file to hopefully avoid getting an RFE because now they have what they need. But keep the second one with you in case that interfile does not actually make it into the file, then you'll still have one available to respond to an RFE. But that is a great way to speed up the process so you can get your approval faster.
Emily, I need your attention in the question posted by Sequence Master from YouTube. His H-1B has been revoked. And now his wife is outside the country, though. Can she enter into the country, though? Let me explain the background for the other people to understand. Of course, Emily knows it. Is that when people are, this is for, he has some reckless misdemeanor driving. So for the people who are getting their H-1B revoked, their H-4 dependents are also getting revoked. What do you answer? Whether she can come into the country, though?
Yeah, I would say we've definitely seen the H4 also getting revoked. It's not 100% across the board. It may be a good idea to check the status of the case for her H4 online in that SEAC system to see if it does say that it is revoked as well, and maybe she just didn't get the email notification. Otherwise, I don't know. Do you think it's safe for her to travel? Is she going to have difficulties at the port of entry if she even has the valid visa?
I would tell her not to travel right now. I would be watching the other people getting traveling and see if they're getting deported or they're getting allowed to come into the country. And then I will tell her, hey, look, the other people got deported, you don't come in. Or everybody came in safely, you can come in. So I would have her wait for a month to see what's going on. We do have this YouTube channel where people give his information. We do have a daily conference call where people come and give the information. We do get a lot of information. Not only that, we do have a law firm where like we have like 17, 18 lawyers. We exchange information. But right now, our advice is to wait for a month to see if how the things are going with the other person, unless you want to be the scapegoat, which I don't want you to be scapegoat. Let's wait for a month to see how the things will turn out about other people.
Blue says, once the priority date becomes current as per the January visa bulletin, how much time does it take for the rest of the process to complete? It really varies. A lot of times we see that once the date becomes current, if they've completed all of the other steps, we start seeing a lot of approvals in the same month, which is great. But sometimes cases get stuck. Sometimes it takes 2 or 3 months. Sometimes it takes longer. Sometimes we have to do a supplement J to try to get things moving or submit the medical exam. Sometimes it's waiting for a visa interview appointment at the local office if they decide to interview the case. So it really is all over the board. It could literally be 1 month. It could be 12 months, anywhere in between. There's no rhyme or reason to it, unfortunately.
Does speeding ticket without any arrest or conviction lead to any visa revocations? No, if it's just a simple speeding ticket without any arrest or any detention, we are not expecting any visa revocation. We have not seen any visa revocation.
Babu Rajendran says, I'm in the US on a pending B2 extension with a change of status to H1B that has been filed. Should I make my social media public? It's definitely not necessary for you to do that for this process. Where you need to make it public is only when you're going for stamping at the consulate outside the US. USCIS does not require that you have your social media public. It doesn't ask for your social media handles like the DS-160 does, so it's not required.
My company is planning to file an H-1B amendment plus extension, but the H-4 and EAD for my spouse is expiring in 210 days. Can I include the H-4 and EAD in the same packet? We strongly recommend you do include it with the packet. We have had no difficulties, even though if it's been expiring for more than 180 days in this particular situation, you can include it. We don't see that as a problem at all.
Himanshu says, what do you think will be the impact of the increase of the prevailing wage? Will it survive in the courts if they try to increase it drastically? Will they increase it like they did in 2021? So we know that there is a proposed regulation to change how they calculate the prevailing wages. We can assume that it's going to increase the prevailing wages since the Trump administration is claiming that H-1Bs are being abused and they should go to more high wage individuals. What we don't know is how exactly it's going to look because it hasn't been published yet. It's only been submitted as a proposal to the OMB, Office of Management and Budget, for them to do their kind of initial review. They have to clear it, and then they'll actually publish the proposed regulation. That will tell us what they intend to do. Then they'll have to wait for comments. So they'll give us 30 days to comment, maybe 60 days to comment. They'll hurry up and maybe look at the comments and then decide to issue a final regulation. Once that final regulation takes effect, then we'll see how they're going to actually implement it because they might change things from start to finish. But I would say it's guaranteed that the wages are going to be higher than what they currently are. Whether it will survive the courts is really how they go through the process. Does the methodology they chose make sense? Because for prevailing wages, the whole point of it is to make sure that the US worker and the foreign worker are being paid at the same rate, that the foreign worker is not undercutting US wages. That does not mean that the foreign worker must be paid higher than the American worker. They just need to be equal. And so if these prevailing wages are coming back higher, requiring companies to actually pay foreign workers more than American workers, I'm not quite sure what that accomplishes and whether it's in line with what Congress intended.
A question from YouTube is he's working as a managerial role stuck in India. If I continue work for India for 12 months, will I be eligible for EB1C? Or can I move on O1 or L1? Definitely, you have to consider that if you're stuck in India, but are you on the payroll of the Indian company? Or are you on the payroll of the US company? If you're on the payroll of the US company, you will not be eligible for the L1 visa or EB1C. You must be on the payroll of the Indian company, though. Now, other than that, you also need to meet the criteria, what is required for EB1C. So definitely, it may be worth for you to consult an immigration lawyer to make sure that you are qualified for EB1C or not. So since you're already there, sitting there, you might as well do this extra thing and try to get the EB1C qualified.
Ami says, anyone get the national interest exemption for this $100,000 fee yet? Not that I'm aware of. If they have, no one has publicly posted it, but based on talk amongst immigration attorneys, a lot of people have submitted them. No response back on any of them. It appears to be just kind of a sham process at this point. So as far as we know, no one has gotten one.
I have this question is coming from Mohan. His advance parole is valid until 2029. When he recently traveled and entered back into the United States, they only given a DA, that is the I-94 only valid for 1 year. Does that mean he can only travel within this 1 year, or can he travel until the expiration of the advance parole? You can ignore the I-94 you can travel after the expiration of the N-94 as long as you have the advance parole that is still valid. You can travel. I don't see that as a problem at all.